Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about refugee litigation. Cases that should have gone to the Supreme Court of Canada, but didn't. The Canadian Association of Refugee Lawyers challenged an action made by the Minister of Citizenship and Immigration on the basis of the fact that it was wrong. What the Minister of Citizenship and Immigration had done was take decisions made by the Immigration and Refugee Board of Canada and use those decisions as frameworks for what it called jurisprudential guidelines, effectively a manner in which a case was determined that had precedential value for the purposes of determining other issues of similar way, in the same way that we see cases of courts being relied on by other courts to determine legal issues. The problem, the Canadian refugee lawyers argued, was that the jurisprudential guidelines didn't just include guidelines for making legal decisions, it also included guidelines for making factual determinations. Essentially, the Minister of Citizenship and Immigration had created pre-canned facts that had already been found in other cases that could be then imported into the cases that were being heard involving the refugee claims going forward. That facts from other cases could have bearing on the facts in cases in the future. This is something that was unheard of in Canadian law. In our system of law, it is obviously only legal conclusions that arise. And yet, the court upheld the minister's ability to do this, finding that it was perfectly okay for the minister to create jurisprudential guidelines that included factual determinations that had already been made, even though the evidence and the facts had not been heard by the tribunal, because it fell within the realm of reasonableness, as it was within the authority of the minister and the minister's agents to do so under the legislation. And this, of course, engages questions about the reasonableness standard. If an action is reasonable, it should be palatable, right? And yet the decision to essentially predetermine the facts of a case before they've occurred is not palatable in the circumstances of any case. I mean, nobody could consider that they'd had a fair hearing as a result of their case being determined on the facts of another case that didn't match the evidence or facts in their own case. And yet that is how these cases are being determined. This was an opportunity for the Supreme Court of Canada to at least put a band-aid on a bleeding bullet hole of administrative law, where the reasonableness from a common sense perspective has just gone out the window, where the legal standards that are applied and one would expect in a hearing that has such a significant bearing on your rights as an immigration or refugee hearing, does not have the same potential and procedural protections that you would get in a criminal case. How can it be that administrative law has gone so far down this path that now you don't even need to have a hearing because somebody's already decided the facts and the law and thus the outcome of your case? This was an opportunity for the Supreme Court of Canada to put a stop to what is obviously a very troubling procedure, and unfortunately they just missed the opportunity. Hopefully another case comes before them soon, before administrative tribunals across this country just start deciding cases that they haven't even heard yet. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.